I'm Drew Stevenson, and this is a very short lecture for my professional responsibility class or for preparing for the MPRE about legal fees and legal ethics. And we're going to make one very simple point here about legal fees in death penalty cases. So the ABA has put out some guidelines apart from the model rules that we study in my professional responsibility class. So these are guidelines specifically about representing death penalty defendants. So that could be a trial or a death penalty appeal. And one aspect of the guidelines does pertain to fees, and I want to mention that in case it comes up as a test question. The ABA guidelines unequivocally disapprove of flat fees in death penalty cases precisely because such fee agreements pit the client's interests against the lawyer's interests in doing no more than what is minimally necessary to qualify for the flat payment. Now, remember that under 1.5, C, you're not, and D, you're not allowed to charge a contingent fee in a criminal case. So you're not going to be charging a contingent fee either. You're going to pretty much have to charge a bill by the hour if you're doing a death penalty case. And the concern is that if you charge a flat fee, then at some point you either from the get-go have the motivation to do as little as possible, because that means you're earning more per for the few hours you spend, or at some reason you at some point after, if you have the case goes on, you start to feel like you're working for free. And we don't want lawyers to sort of give up on death row inmates that they're or people facing the death penalty because the stakes are so high. So basically that leaves you only the option of charging an hourly fee if you do death penalty cases. And that's the whole point of this video, in case you see that as a test question.